Hi, my name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about the interpretations and debates of the US Supreme Court and civil rights in Edexcel A-Level Politics. This is the final of 6 videos on the channel in relation to the US Supreme Court and civil rights, and it's probably the most important. It's going to be a pretty long video. I'm going to start by looking at the parts of the specification the video covers and the key essay questions that could come up on the topics. I'm then going to go into some really key debates across the Supreme Court and civil rights. First, looking at the political versus judicial nature of the Supreme Court. We'll look at the appointments process, judicial activism, and its role in the political system. I'm then going to look at living constitutionalism versus originalism. I'm then going to look at how effectively civil and constitutional rights have been protected, the extent of the Supreme Court's powers and the effectiveness of checks and balances, and finally looking at the successes and failures of measures to promote equality, including affirmative action and immigration reform. Pretty much all of this video is going to touch on previous videos, whether it's on the appointments process in the Supreme Court and its impact on public policy, or on race and rights in the US and protection of civil rights through the Constitution. So make sure to have a look at those first, because these debates will make a lot more sense. You'll have a lot more detail if you have a look at those too. So yeah, the PDF you can see on your screen is part of an updated textbook on the US part of the course for Edexcel A-Level Politics, which you can purchase on the Politics Explained website. We can also purchase loads of other resources to help you in your politics A-Level, including essay plans, updated textbooks, and there's also a place to sign up for tutoring if that's something you'd be interested in. So yeah, without further ado, let's get into it. So starting off with the parts of the specification this video covers. So this is in, as I said, US Supreme Court and Civil Rights, and it's 4.6, Interpretations and Debates of the US Supreme Court and Civil Rights, looking at the political versus judicial nature of the Supreme Court, living constitutionalism as an ideology against originalism, how effectively civil and constitutional rights have been upheld by the Supreme Court and the effectiveness of this protection, the extent of their powers and the effectiveness of checks and balances, the successes and failures of measures to promote equality, including affirmative action and immigration reform. In terms of the potential essay questions you can get on this topic, so effectively, this video is going to be really useful for pretty much all of the 12 markers and 30 markers you can get on the US Supreme Court and civil rights, as well as potentially being useful in relation to some of the cross-cutting questions that come up quite a lot in the 30 markers. So pretty much all of these 12 markers it's going to be useful for, and also lots of others you could be asked, as it's quite difficult to predict the particular 12 markers on the exam. So you could look at the roles and powers of the UK and US Supreme Courts, differences in rights protection, the effectiveness of pressure groups at protecting rights. So a wide range of different questions, and effectively different parts of this video are going to be useful for all of them. And it's exactly the same for these 30 markers. So is there now an imperial judiciary? Is the Supreme Court political rather than judicial? How well are rights protected by both the Constitution and Congress, and comparing different groups in their protection of rights? Generally, measures to promote equality being effective, and that's going to be looked at in the final part of the video. So yeah, pretty much all of these questions, but also, as I said, it's also going to touch on a lot of the previous topics and videos. So there's going to be more detail in the previous videos, so it's worth noting those as well. But effectively, yeah, there's going to be a lot of the key arguments in relation to these questions in this video. So, starting off with the political versus judicial nature of the Supreme Court, which, as I said, could be a key question that could come up. And effectively, the way we're going to analyse this is by looking at 3 key topics, and these could be your themes in an essay on this topic. Firstly, looking at the appointment process, which obviously looked at in a whole video in a lot more detail. But first argument that the appointment process is politicised is that it's influenced by partisan political considerations rather than purely judicial qualifications. And I suppose the first key argument before we look at this is that ultimately, what is the key reason why politicians and presidents nominate certain justices? And for me, as we looked at kind of in the appointment process, there's a range of considerations, but potentially the most important one is their ideological balance, and whether their ideological intentions, what their interpretation of the court is, of the Constitution, and how they're likely to rule, and whether that aligns with the president's political priorities and how they'd like the court to rule. So Republicans appoint conservative justices, and Democrats appoint liberal justices. And crucially, that can be argued to be politicised, as they're ultimately trying to get a certain political outcome from the Supreme Court's decisions. Further, the appointment process itself has been fundamentally politicised. So, and this can really be seen by comparing Merrick Garland's nomination and Amy Coney Barrett's in 2020. So Garland, who was nominated by Obama, was not granted a Senate hearing, with the Republican-controlled Senate arguing that a Supreme Court vacancy should not be filled in an election year, as this was in 2016. But the precedent was not followed in 2020. So effectively what happened with Garland is he was nominated by Obama, but the Supreme Court, the Senate rather, refused to hear him, and ultimately then it was waiting until the election, and Trump was able to then appoint Neil Gorsuch instead of him, a conservative justice rather than Garland, who was a liberal justice. And that was obviously clearly in the Republican Senate's interest and the Republican Party's interest, and it was clearly motivated by political motives. This precedent wasn't followed by the same or very similar Republican Senate in 2020, when Trump successfully nominated and confirmed Amy Coney Barrett in the Supreme Court just days before the presidential election. So this highlights the influence of political strategies over judicial appointment process, indicating a departure from a purely meritocratic and judicially focused system to one heavily influenced by partisan politics. And crucially, this can also be seen in voting patterns in the Senate confirmation. So historically, they were very bipartisan because they were focused on even if ideological considerations were important, the Senate focused on, okay, were they qualified candidates with extensive judicial experience? So you see Justice Antonin Scalia was confirmed 98-0 in 1986, for example. That's not been the case at all in recent nominations. So in the confirmation of Kavanaugh in 2018, he was confirmed with one of the narrowest margins in history, with a 50-48 vote, with just one Democrat voting for him, Senator Joe Manchin. And this is trend towards partisan voting is reflective of a broader shift in how nominees are perceived and evaluated, with their political and ideological leanings often overshadowing their legal expertise. And as I said, it's also the primary consideration for presidents when appointing Supreme Court justices is the extent to which their interpretation of the Constitution aligns with the policy aims of the president. On the other hand, it can be argued that the appointment process guarantees judicial integrity and the legal qualifications of nominees, and therefore isn't politicised. There's extensive vetting procedures, including detailed examination of candidates' judicial philosophies and past rulings, including by the Senate and the Senate Judiciary Committee. So though the Constitution doesn't mandate any particular legal expertise, all Supreme Court justices have had significant legal expertise. The nominees also face the Senate Judiciary Committee, where they undergo extensive questioning on various legal and constitutional matters. And these hearings are public, allowing for transparent evaluation of the nominees' legal acumen and their views on critical legal precedents and constitutional interpretation. The appointments of Justice Ketanji Brown Jackson and Amy Coney Barrett, though occurring in politically charged environments, involved comprehensive reviews of their legal backgrounds. So Ketanji Brown Jackson's appointment was marked by a thorough examination of her judicial record and her experience as a federal public defender, reflecting a focus on her diverse legal experience, whilst Amy Coney Barrett's hearings concentrated on her judicial philosophy and past rulings, particularly regarding healthcare and abortion, reflecting an attempt to assess her legal approach and expertise. And these demonstrate the increasing influence that despite the increasing influence of politics in the nomination process, aspects of the procedure remain dedicated to evaluating the legal qualifications and judicial temperament of nominees, ensuring that the court upholds its role as primarily as a legal institution. In terms of judicial activism, there's one key argument that judicial activism means that the Supreme Court is too politicised, and that's because there's been a number. It can be argued that the Supreme Court acts, or many Supreme Court justices act based on judicial activism, where their rulings are influenced by personal or political considerations rather than simply judicial ones, showing that the court is politicised. And this is characterised by broad interpretations of the Constitution, overturning precedents and expanding rights beyond their explicit wording, often reflecting the ideological leanings of the justices. So liberal judicial activism was notably prominent during the Warren Court era, where Chief Justice Earl Warren, his landmark decisions such as Brown v. Board of Education and Miranda v. Arizona, substantially expanded civil rights and liberties, signalling a proactive role in shaping social and legal issues. And they also expanded the federal government's role, in particular Congress. These decisions, though celebrated for advancing civil rights, were seen by critics as the court overstepping its traditional interpretive role and using its interpretive role to promote policy goals of advancing civil rights, which they shouldn't be doing, as they should simply be upholding the Constitution. In recent years, it can also be argued that there's been a shift towards conservative judicial activism under the Roberts Course. Cases like District of Columbia vs. Heller and Citizens United demonstrate the court's willingness to reinterpret the Constitution in ways that align with conservative ideologies, expanding gun rights and altering the landscape of campaign finance, respectively, in ways that overturn previous precedents in the understanding of the Second Amendment and First Amendment, respectively. Further, the overturning of Roe v. Wade in 2022 overturned a nearly half-century precedent set by Roe v. Wade and is seen as a stark example of conservative judicial activism. His decision, critiqued for reflecting the justice's personal beliefs rather than neutral application of the law, illustrates the court's significant role in shaping the legal system and societal norms. And it was effectively, the overturn was the consequence of the nomination process and the fact that Trump had been, due to the unpredictability of vacancies, been lucky in being able to appoint 3 conservative justices, which solidified a strong 6-3 conservative majority on the court. On the other hand, it can be argued that the Supreme Court isn't politicised due to judicial activism. So contrary to the perception of politicisation through the judicial activism, there are compelling arguments that in many of its decisions, the Supreme Court maintains its judicial integrity and has refrained from political activism. So in Dobbs v. Jackson Women's Health Organisation, it can be interpreted not as a conservative judicial activism, but as a correction of the liberal activism seen in Roe v. Wade. The Dobbs decision, which overturned Roe v. Wade, was based on the argument that the Constitution does not explicitly mention abortion, and that abortion isn't actually protected under a right to privacy in the 14th Amendment, thus interpreting Roe v. Wade as an overextension of constitutional reading and a deviation from a kind of textualist and originalist understanding of the Constitution, and therefore correcting that through the Dobbs case. Moreover, the Roberts Court, despite its conservative leanings, has demonstrated a balanced approach in several landmark cases, issuing rulings which have advanced liberal values, such as Upheld v. Hodges, which legalised same-sex marriage, and Boston v. Clayton County, which expanded workplace protections to LGBTQ individuals. And this shows that the court's commitment to protecting individual rights and adapting to societal changes. And we argue that these cases show that the Supreme Court isn't politicised and activist, but in fact practices judicial restraint and seeks to implement the Constitution as it's written through a textualist approach. Further, it can be argued that judicial activism is sometimes necessary for the evolution of law and society. It allows for the adaptation of legal principles to changing societal norms and fills gaps where legislative action may be lacking or insufficient, which is key to safeguarding civil liberties and ensuring the legal system remains relevant and responsive to current challenges. And that can be seen in Riley v. California, which effectively updated the kind of interpretation of digital privacy and the Fourth Amendment to apply it in modern contexts. Finally, key kind of theme to look at is its role in the political system. Firstly, looking at the argument that the Supreme Court is politicised due to its role in the political system. And this can be argued that it's gone beyond simply interpreting and upholding the law in the Constitution, and that instead its decisions have profound political implications, and it can be used to halt President and Congress's agenda in a way that reflects the interests of the political balance of the court. And this is crucially its role in terms of judicial review. In June 2023, it struck down Biden's student loan forgiveness program, which aimed to cancel significant amounts of student debt for millions of Americans. The decision, rendered by a conservative majority on the court, not only halted a central component of Biden's domestic agenda, but also highlighted the court's capacity to influence national policy direction. Further, some of the most important political changes come not from legislation passed by Congress, but from decisions made by the Supreme Court, which explains why the political parties place so much emphasis on their nominations and why it's become the nomination process has become quite politicised. This is in particular case with the Conservative shift in the court in recent years, with really key decisions on affirmative action, on abortion, on campaign finance, on gun control, and these have massive implications for US political life and US life in general, in terms of tackling inequality, abortion rights, and campaign finance. Different ways to interpret the Constitution are ultimately matters of political division and motivation, with conservative judges supporting an originalist position, which favours the policies of the Republican Party, and liberal justices supporting a liberal constitutionalist position, which supports the policy aims of the Democrats. So that's the argument that its role in the political system is politicised, because it kind of plays a key role in halting a president's agenda, especially when it's not particularly aligned with that president's interpretation of the Constitution, and B, because it has such an impact on US political life and the Constitution. That's ultimately not necessarily what its key role is. Its role is to uphold the law. It shouldn't be the key body in the US making these massive changes, which it can be argued it's become. On the other hand, though, it can be argued that the Supreme Court isn't politicised due to its role in the political system. It can be argued that despite its significant impact on national policies and political discourse, The Supreme Court fundamentally serves the role of adjudicating and upholding the law and its constitution, which is a role given to it in the constitution and isn't politicised. The court's decisions, even if they have substantial political implications, are really rooted in legal interpretation and the application of constitutional principles rather than political motivation. So, for example, when the Supreme Court struck down the effort by Colorado to disqualify Trump from running for president using an anti-insurrection clause in Trump v. Anderson in 2024, which is really recent, the decision was a unanimous one that ruled that only Congress has the authority to do so in the Constitution. So it's a judicial decision, not a political one, despite its profound political implications for the presidential election in 2024. Different approaches to the Constitution, in particular whether judges are originalists or living constitutionalists, are about legal interpretation, not about politics. It can be argued that the essence of the court's role is to interpret the Constitution and ensure that laws and executive actions are in compliance with it. And this, by its nature, can lead to rulings that have political ramifications, because that means it can strike down key laws suggested by Congress and policies suggested by the executive. So the decision to strike down Biden's student loan forgiveness program was based on legal grounds, with the Supreme Court judging that the HEROES Act allows the Secretary of Education to waive or modify provisions for loan forgiveness, but doesn't authorise a complete overhaul of the student loan system that Biden sought. While the outcome certainly affected the administration's agenda and therefore had political consequences, it was centred on interpreting the law as per the Constitution, which is a core function of the judiciary and the Supreme Court, and kind of reflects the fact that it's a judicial institution. Moreover, the Supreme Court serves as a crucial component in the US system of checks and balances. Its ability to review and potentially overturn legislation or executive actions is a safeguard against overreach by other branches of government. And in recent rulings such as Dobbs, while the political implications are undeniable, it can be argued that this reflects the court's interpretation of constitutional rights and precedents rather than being politically motivated. So even in cases where the court's ruling align with certain political ideologies, these decisions can be seen as more reflective of their interpretation of the law and the Constitution rather than direct political interference or bias. So yeah, there are quite detailed arguments on either side, and I think, as you can see, there's some really strong arguments on either side, and it's quite difficult to come up with a particular conclusion in relation to this argument, but this is a really key question you could get asked in the exam. So definitely worth having a thinking about. Okay, you're not going to be able to include all of this at all in the essay, so think about which points you include. Obviously, look at the essay plans that are soon going to be on the website, and by the time many of you are looking, these will be on the website in relation to kind of how I've done it as well, if you're interested. But just think about it, you're not going to be able to include all of these arguments. So what are the key arguments on either side, and what are you going to conclude? Next thing we'd have a look at is, which we've touched on a little bit, is living constitutionalism versus originalism. These are different interpretations of the Constitution. So living constitutionalism is an approach to interpreting the Constitution that sees the meaning of the text as evolving over time to reflect contemporary social values and an ever-changing context. It sees this as necessary to ensure the Constitution remains relevant and effective in addressing modern challenges. And they argue that this was how the Founding Fathers intended for the Constitution to be interpreted, which is why it was kept deliberately short and vague in areas. This interpretive framework allows for a more dynamic and adaptable application of constitutional principles rather than a strict adherence to the original intentions of the framers or the literal wording of the document, and it's commonly held by liberal justices. And we can see this in relation to a number of amendments. Perhaps the most important one, the most politically significant one, is the 14th Amendment. So the living constitutionalism approach interprets the 4th Amendment broadly, viewing it as a dynamic provision that adapts to contemporary understandings of equality and civil rights. So this expansive interpretation of the equal protection and due process clauses of the amendment has been instrumental in extending constitutional protections to evolving societal norms. So in the landmark case of Upheld v. Hodges, the Supreme Court, guided by this approach, held that the 14th Amendment requires states to license and recognise same-sex marriages, reflecting modern views on marriage equality and civil rights and LGBTQ rights. Similarly, in Roe v. Wade, the court utilised a broad interpretation of the amendment's right to privacy to justify the legalisation of abortion, acknowledging evolving perspectives on women's reproductive rights and autonomy. You can also see it in the 4th Amendment, which has interpreted the 4th Amendment, which protects against unreasonable searches and seizures in a manner that adapts to the evolving nature of privacy and technology in the modern era. So you can see this in Riley v. California, which we've looked at in a number of videos now, where the court ruled that the warrantless search and seizure of digital contents of a cell phone during arrest is unconstitutional. And this expanded the 14th Amendment's privacy protections to the digital realm, acknowledging the profound changes in how personal information is stored and accessed in the age of smartphones. So the living constitutional approach updated it to the modern day. We'll also look at it in relation to the First Amendment. So the Supreme Court has interpreted the First Amendment, which safeguards freedom of speech, religion, and expression in a way that adapts to the evolving societal understanding of discrimination and equality. And a key example of this is Bostock versus Clayton County, where the court ruled that discrimination based on the individual's sexual orientation or gender identity is a form of sex discrimination prohibited under the Civil Rights Act. And this reflects an expanded interpretation of the First Amendment's principles in the context of modern understandings of gender and sexual identity, acknowledging the shift in social values towards LGBTQ rights and equality. And then finally, key one we're going to look at is the 10th Amendment. So the Supreme Court has interpreted the 10th Amendment, which reserves powers to the states and the people that are not delegated to the federal government in a manner that acknowledges the evolving nature of federalism and the balance of power in the US. A key example of this is Heart of Atlanta Motel versus United States in 1964 as part of the Warren Court, where the court upheld the constitutionality of the Civil Rights Act under the Commerce Clause. And this marked a significant extension of federal power, justifying anti-discrimination measures in private businesses engaged in interstate commerce. So effectively, they defined accommodation, such as motels, as interstate commerce, which justified the constitutionality of the Civil Rights Act under the Commerce Clause, even though other interpretations of the Constitution may have said that's a bit too much of a stretch for Congress's role in regulating interstate commerce. And it shows how the living constitution approach adapts the 10th Amendment's principles to contemporary societal needs, allowing for a broader federal role to combat racial discrimination. In contrast to living constitutionalism, the opposite approach is originalism. And this originalist approach to interpreting the Constitution emphasizes understanding and applying the text based on its original meaning and the intent of the Founding Fathers at the time of its drafting and ratification. It argues that the Constitution's meaning is fixed and should not evolve over time, ensuring that changes to its interpretation are made through the amendment process, not through judicial reinterpretation. And this therefore takes a very textualist approach, strictly adhering to the plain and original meaning of the text without inferring intentions or considering contemporary social contexts. Originalists believe that this approach maintains the Constitution's integrity and respects the intentions of the Founding Fathers, thereby upholding the rule of law, the principles of the Constitution, and preventing judicial overreach. We can see this in a number of cases, for example in relation to the First Amendment, which protects freedom of speech, religion, press, assembly, and petition. An originalist approach to this amendment closely adheres to its text and the historical context of these freedoms as understood at the time of its ratification. And a key example of this in a case is Citizens United, where in this ruling the Supreme Court, applying an originalist perspective, held that the corporate funding of independent political broadcasts is a form of protected speech under the First Amendment. This reflects the originalist view that the amendment's protection of free speech extends to all entities, including corporations, in line with the historical understanding of free expression at the time the amendment was adopted, irrespective of this impact on campaign finance in US elections. Irrespective of the fact that this would facilitate wealthy individuals and corporations having loads of influence, much more influence than others on US elections, ultimately that doesn't matter. It's about interpreting the Constitution as it was originally intended and as it's written. We can also have a look at the 10th Amendment, which delineates the division of power between the federal government and the states. And this amendment, when interpreted by originalists, reinforces state rights and curtails federal overreach. And a key example of this is Shelby County versus Holder. And in this case, the court, through an originalist lens, struck down key provisions of the Voting Rights Act, arguing that they infringe on states' rights protected by the 10th Amendment. This overturned previous judicial interpretation that held that the Voting Rights Act was constitutional due to the fact that it promoted equal protection under the 14th Amendment. And it highlighted the amendment's original intention to maintain a balance of power between the federal government and the states, even if this interfered with the promotion of racial rights and civil rights in the US. And the final one we're going to have a look at is the 14th Amendment, and this is applied to the 14th Amendment, particularly its equal protection and due process clauses, which are really important. And originalists interpreted this amendment by adhering closely to its text and the historical context at the time of its ratification, emphasizing state sovereignty and individual rights as originally intended. A key example of this is the overturning of Roe v. Wade, and in this case, the court using an originalist interpretation overturned Roe v. Wade, arguing that the Constitution does not explicitly confer a right to an abortion, which is not found in the original text or the intent of the 14th Amendment, according to originalists. This ruling effectively shifted the authority to regulate abortion back to the states, aligning with the originalist view that matters not specifically addressing the Constitution should be left to state discretion. And this underscores the originalist perspective that the 14th Amendment's protection of individual rights and due process must be grounded in the amendment's original meaning, rather than the expanded interpretation to, as they see it, unfairly create a constitutional right to an abortion, which isn't there under kind of the privacy provisions of the Due Process Clause. Another significant application of originalism to the 14th Amendment was in the case of students versus fair admissions in relation to affirmative action, which we looked at in the previous video, where the court, maintaining the originalist stance, reversed previous rulings that permitted race-based affirmative action in college admissions. And this decision, in line with the originalist principles, reflected the view that such policies were not in keeping with the original understanding in the text of the equal protection as envisioned by the amendment's framers. In relation to key justices in the current Supreme Court and their different interpretations, a key originalist is Justice Clarence Thomas, who's renowned for his originalist judicial philosophy, reinterprets the constitutional and legal statutes according to their original meaning and the intent of their framers at the time of enactment. He consistently adheres to this approach, focusing on the historical context and original language of the Constitution to guide his decisions, rather than contemporary interpretations or societal shifts. This can be seen when Thomas concurred with the majority in overturning Roe v. Wade, advocating an originalist position of the Constitution that does not recognise a federal right to an abortion. Again, in Shelby County v. Holder, he agreed with the majority in striking down key provisions of the Voting Rights Act, demonstrating his originalist perspective on state rights and federal powers under the 10th Amendment. Chief Justice John Roberts can be seen as a pragmatic originalist. So he's known for a judicial approach that often integrates elements of originalism with consideration for the pragmatic impact of the court's rulings. So he's kind of in between. He interprets the Constitution by considering its text and the historical intentions of its framers, whilst also weighing the practical consequences of judicial decisions. And this can be seen in the key case in relation to the Affordable Care Act, which was National Federation of Independent Business v. Sebelius in 2012, where Roberts upheld the individual mandate of the Affordable Care Act as a constitutional exercise of Congress's taxation power. And his decision, though contested as not strictly originalist, displayed a blend of textual analysis and judicial pragmatism, focusing on the law as written by Congress and its alignment with constitutional principles. In Upheld v. Hodges, he dissented, emphasising judicial restraint and criticising the majority for extending the bounds of the judiciary. So he's kind of in between. A key living constitutionalist is Justice Sonia Sotomayor, who's a liberal justice. And she's recognised for her approach that often aligns with living constitutionalism, interpreting the Constitution as a dynamic document that evolves with contemporary societal values and contexts. She tends to consider the implication of the court's decisions on society, particularly on marginalised communities. And in Upheld v. Hodges, she joined the majority in expanding the interpretation of the 14th Amendment to include the right to same-sex marriage. And she therefore viewed the Constitution as adaptable to modern understandings of equality and civil rights. Whereas conversely, in Dobbs v. Jackson Women's Health Organisation, her dissent strongly criticised the majority's decision to overturn Roe v. Wade, a ruling she argued disregarded decades of precedent and women's reproductive rights. And her dissent emphasised the evolving societal standards and the need for constitutional interpretation to reflect contemporary views on autonomy and privacy and the right to an abortion, consistent with the principles of living constitutionalism. Okay, so there were some key debates in relation to the Supreme Court specifically. What we're going to look at now is moving on to civil rights and how effectively civil and constitutional rights have been upheld. First, we're going to look at some arguments civil and constitutional rights have been upheld in the US. Firstly, looking at how rights have been effectively protected by Supreme Court decisions that take a living constitutionalism approach. So it can be argued that it's played a key role in advancing civil and constitutional rights through key landmark rulings that protected civil rights by reinterpreting the Constitution to kind of offer protection in a changed society that recognises the need for the protection of these rights for minority groups and individuals across society. A key example of this is Brown versus Board of Education, which reinterpreted the Constitution, ending the separate but equal doctrine and therefore getting rid of racial segregation in schools. You can also see it in Upheld versus Hodges, which reinterpreted the 14th Amendment as allowing same-sex marriage, therefore extending rights and legalizing same-sex marriage in the US. It can also be seen in Riley versus California for kind of updating the Constitution to reflect changes in modern technology in order to protect digital privacy in this context by protecting against the warrantless search of cell phones, given the fact that they might be a physical item, but they have a high amount of personal information on them. Rights can also be seen as effectively protected by the Constitution, by the Bill of Rights specifically, and an originalist interpretation of them. So the Constitution and Bill of Rights serve as fundamental safeguards for civil and constitutional rights in the United States. Key Supreme Court rulings have been effectively protected by a wide array of rights, ensuring that constitutional liberties are not infringed upon by the government or other entities. And many of these rulings take an originalist interpretation of the Constitution, ensure that fundamental rights aren't infringed upon and continue to be protected. This can be seen in the Second Amendment in District of Columbia versus Heller, where the court affirms the Second Amendment's protection of an individual's right to possess a firearm, unconnected with service in a militia. And this clarified an individual's rights interpretation of the Second Amendment, reinforcing the right to bear arms for self-defense within the home. In Citizens United, it can be seen as protecting freedom of speech in the First Amendment, underscoring that free speech extends to all entities, including corporations. And in Students for Fair Admissions, it can be argued that the striking down of affirmative action was key to protecting rights, reflecting a shift towards a kind of originalist understanding of equal protection and protecting against discrimination based on race. Whilst the overturning of Roe v. Wade can be seen as protecting the rights of states to decide on reproductive rights. It can also be argued that rights are effectively protected by the government and Congress. So the effective protection of civil and constitutional rights is also bolstered by legislative actions of the government and Congress. And these legislative bodies have played a pivotal role in enacting laws and reforms that extend and safeguard the rights and liberties of Americans. So, building on a lot of what we've looked at in previous videos, a key example of this is the Voting Rights Act, which is a key piece of legislation that aimed to overcome legal barriers at the state and local levels that prevented African Americans from exercising the right to vote. It can also be seen in the Affordable Care Act, which represented an overhaul of the healthcare system, extending health coverage to millions of uninsured Americans. It can be seen as kind of extending a right to healthcare in the US. And more recently, the First Step Act of 2018, which is a bipartisan piece of legislation, kind of reformed the criminal justice system, aiming to reduce the federal prison population and create fairer, more efficient sentencing laws. And finally, it can be argued that rights are effectively protected by interest groups and social movements. So these groups often mobilise public opinion, influence legislation, and sometimes bring issues to the judicial system, thus contributing significantly to the protection and advancement of rights. Black Lives Matter is a prominent example of a social movement that had a substantial impact on rights. Through protests, advocacy, and media campaigns, BLM has brought issues of racial justice to the forefront of public discourse, influencing legislative and societal shifts towards greater equality and accountability in law enforcement. And these have been key in raising awareness about racial equality, particularly in the criminal justice system. And has influenced, as we looked at, local in previous videos, local laws in relation to policing. For example, California passed Assembly Bill 392, which changed the standard of force, standard for police use of lethal force from when it's reasonable to when it's necessary. The National Rifle Association can also be seen as an interest group that has significantly protected Second Amendment rights. The NRA actively lobbies against gun control legislation and works to protect and expand gun ownership. And it played a really key role in preventing the passage of the 2013 Manchin-Tooney Amendment through significant lobbying. And this amendment sought to expand background checks for all gun purchases, including at gun shows and online sales. On the other hand, there's a number of arguments that civil and constitutional rights haven't been effectively upheld. First of all, it can be argued that they haven't been protected by the current conservative Supreme Court and its originalist interpretation. We argue that this has led to significant concerns about the effective protection of civil and constitutional rights, as it's resulted in rulings that have rolled back key protections and reshaped the legal landscape in ways that many argue limit individual rights and freedoms. Key example of this is Dobbs v. Jackson Women's Health Organisation, which overturned the landmark Roe v. Wade ruling and removed the constitutional right to an abortion, therefore giving the power back to the states, and that's resulted in many individual states removing the right to an abortion, particularly those controlled by Republicans. Another case, Shelby County v. Holder, kind of invalidated key provisions of the Voting Rights Act, which was a really key piece of legislation that promoted the rights of minority communities to vote. And as we looked at in the previous video, that had immediate political consequences in a number of pieces of legislation being introduced at the state level that go against or kind of limit the ability of African Americans to vote. A number of other conditions, so students thus fair admissions, can be seen as kind of removing equal access to education and employment through removing the constitutional right to affirmative action or the constitutionality of affirmative action, while Citizens United can be seen as kind of facilitating the erosion of democracy through the role of money in politics and in elections due to its interpretation defining corporate spending as free speech. It can also be argued that rights aren't effectively protected in the US, as they're not effectively protected by the government and by Congress. So even despite efforts to protect rights, in some cases this is struck down by the Supreme Court, and this can be seen in Shelby County v. Holder, where the Voting Rights Act sought to, and for decades did, kind of prevent discrimination on grounds of race in the United States in relation to voting. That was struck down by the Supreme Court, and that's resulted in the enactment of several state-level laws that kind of disenfranchise minority voters. There's also a number of cases where the Congress has failed to enact important legislation to protect rights. That can be seen in the DREAM Act, which would have provided a pathway to citizenship for undocumented immigrants brought to the United States as children, but that was blocked by the Supreme Court, including, in particular, it was blocked due to the filibuster by Republicans in the Senate. Whilst also you can look at the kind of legislative suggestions or kind of legislative proposals promoted by the Black Lives Matter movement, including the George Floyd Justice Policing Act and the Breathe Act, both of which failed to be passed by Congress. Further, the government can be perceived as encroaching on rights, and a recent example of this is the federal government's handling of immigration enforcement under the Trump administration, where measures like family separations and the implementation of stringent asylum policies raised concerns about the violation of human rights and overreach into areas traditionally managed by the states. And finally, it can be argued that rights aren't effectively protected by interest groups and social movements. So whilst they play a significant role in advocating for civil and constitutional rights, their effectiveness in achieving concrete legislative changes and the protection of rights at a federal level can be seen as limited. So as we looked at in the previous video, I'm looking at kind of race rights campaigns in the United States, and I just noticed Black Lives Matter kind of was a really key movement that generated significant public opinion, but had limited federal government legislative success. As I said, the George Floyd Justice and Policing Act and the Breathe Act failed to be passed, and movements like BLM face opposition from powerful counter movements and interest groups, which can hinder progress. For example, whilst BLM advocates for police reform and racial justice, pro-police and conservative groups push back against these reforms, arguing for the preservation of current law enforcement practices and structures. The NRA's success in lobbying against gun control, whilst effective in protecting the right to bear arms, can also be seen as facilitating major loss of life and the fundamental right to life of US citizens, in particular due to its facilitation of school shootings. And the pro-life movement and interest groups, including the National Right to Life Committee, can be seen as having significantly influenced a shift in the US Supreme Court stance on abortion rights, contributing to the overturning of Roe v. Wade and the removal of the right to abortion. So whilst some interest groups can protect rights, they can also be seen as taking them away. And through the intense lobbying and strategic placement of conservative justices on the Supreme Court, these groups have reshaped the judicial approach to abortion rights and Dobbs v. Jackson Women's Health Organisation. And they also kind of helped to bring that case to the Supreme Court. The next key thing we're going to have a look at is the extent of the Supreme Court's powers and the effectiveness of checks and balances. Firstly, looking at the role of the Supreme Court. We already looked at this in the kind of first video, looking at the Supreme Court, so we'll kind of go over this, but its key roles include it's the final court of appeal, interprets the Constitution through judicial review, creates legal precedents, protects the rights and liberties set out in the Constitution, and checks the power of the executive and Congress through judicial review. And firstly, what are the key arguments that the Supreme Court does have too much power? Firstly, kind of linking to stuff we looked at earlier in the video, it can be argued that judicial activism can be seen as judicial overreach that gives the Supreme Court far too much power by encroaching on the domains of the legislature and the executive branches. This stems from the vagueness of the Constitution. And a key period of liberal judicial activism, as we looked at in a lot of detail already in previous videos and earlier in this video, is the Warren Court era, and the Brown v. Board of Education, Miranda v. Arizona. And although these decisions were celebrated for their progressive outcomes in kind of extending rights, they were also criticised for extending beyond the traditional judicial interpretation of the Constitution and kind of going into the legislative territory. And it can be argued that Congress, rather than the Supreme Court, should make decisions with such profound effects. More recently, the shift towards conservative judicial activism can be seen in a number of cases, such as District of Columbia, which reinterpreted the Second Amendment, and Dobbs v. Jackson Women's Health Organization, which overturned the half-century precedent of Roe v. Wade and removed the constitutional right to an abortion. And this highlights how Supreme Court decisions, driven by the justices' personal or political beliefs, can have profound implications on societal norms and individual rights. And such instances of judicial activism reflect the court's substantial influence in reshaping legal and societal frameworks, suggesting an overextension of its constitutional role and encroachment into the areas that should be controlled by elected bodies, by Congress and the presidency. It can also be argued that 9 unelected individuals have supreme power and far too much power in the Constitution. So the Supreme Court consists of just 9 unelected justices, and it wields an immense amount of power in shaping US policies and societal norms, often making decisions that have profound and lasting political consequences. These justices are appointed for life and not accountable to voters, yet they have the authority to make landmark rulings on critical issues affecting millions. In Citizens United, for example, they transformed the landscape of campaign finance, whilst in Dobbs v. Jackson Women's Health Organization, they overturned Roe v. Wade and drastically altered abortion rights by removing the constitutional right to an abortion. And these illustrate how pivotal decisions, often with widespread political and social implications, rest in the hand of a few unelected judges, raising concerns about democratic legitimacy and the appropriateness of such significant powers being vested in a non-elected body. Moreover, the lifetime tenure of these justices can lead to potential issues of bias and corruption. For example, Justice Thomas has faced significant criticism and allegations of conflicts of interest, raising questions about the integrity and impartiality of the court's decisions. And then finally, it can also be argued that the Supreme Court is influenced by political motivations. So we've looked at this in loads more detail at the start of the video, but you can argue that the court is actually political rather than a judicial institution. Its appointment process is very much influenced by political considerations, and it can be argued that justices are influenced by political considerations when making decisions. Finally, we can look at some arguments that the Supreme Court doesn't have too much power. So we argue that the Supreme Court justices are independent, professional, and experienced. So the independence of the Supreme Court is safeguarded through various constitutional provisions. They're appointed for life during good behaviour, and ensuring they're free from the pressure of re-election or political retaliation. So their lifetime tenure, combined with their salary protections, prevent reductions in their salary during their service, alter their independence from external influence. Their decisions have to be firmly rooted in law, and it can be argued that nominees are chosen for their profound legal acumen. It can also be argued, as we kind of looked at in much more detail earlier on, that judicial activism kind of doesn't give the Supreme Court too much power, but it's actually necessary to update the Constitution for the modern day, as we've looked at in a lot more detail already, but you can feel free to pause the video and have a read through the notes. And it can also be argued that actually the Supreme Court doesn't have too much power, because it's the Constitution that's sovereign, not the Supreme Court. So the Supreme Court's role in American democracy is fundamentally upholding the Constitution and the rule of law, rather than exerting unchecked power. And the court does not initiate legal action or legislation. Its jurisdiction is limited to reviewing and interpreting existing laws and actions in light of the Constitution. And a recent example that underscores this is its role in the decision to strike down the President Biden's student loan forgiveness plan. And this was based on the court's interpretation of the Higher Education Relief Opportunities for Students Act, the HEROES Act, and it determined that while the HEROES Act allows the Secretary of State to waive or modify provisions for loan forgiveness, it doesn't authorise a complete overhaul of the student loan system. So even though this decision had a big impact on politics and stopped a key one of Biden's policies, it was fundamentally rooted in the Constitution, and it's the Constitution that was sovereign, not the Supreme Court. Furthermore, as we looked at in an earlier video, the court often exercises judicial restraint, opting to make decisions based on a narrow interpretation of the law rather than broad policy judgments. And crucially, Congress and the states retain the ability to amend the Constitution if they don't like how the Supreme Court is applying it. So following Oregon v. Mitchell in 1970, where the Supreme Court held that Congress could regulate the voting age in federal elections, but not in state and local elections, the 26th Amendment was passed in 1971, lowering the voting age to 18 in all elections, thereby standardising the voting age across the country. The final thing then we're going to have a look at is the success and failures of measures to promote equality, including affirmative action and immigration reform. First, looking at affirmative action, which obviously we looked at in a lot more detail in the previous video. On the one hand, in terms of successes, it can be argued that it's increased diversity in higher education, which tackles prejudice. And this was upheld by a number of previous Supreme Court decisions before last year, including Grutter v. Bollinger, which upheld the University of Michigan Law School's affirmative action policy, emphasising the educational benefits of a diverse student body. It can also be seen as promoting workplace diversity and promoting equal opportunity. On the other hand, it can be argued to be seen as kind of failing to promote racial equality, because recent Supreme Court rulings have gone against affirmative action, which now kind of effectively it's assumed that affirmative action, at least in university admissions, is against the Constitution, even if it's considered as one of a number of different factors in a holistic admissions process. And that's because Students for Fair Admissions effectively struck down administrative affirmative action and overturned previous judicial precedent to argue that it was unconstitutional. It can also be argued that affirmative action promotes reverse discrimination and creates concerns about merit-based selection and equal opportunity, whilst it also stigmatises beneficiaries and increases racial tension. Again, we'll look at these in a lot more detail in the previous video when looking at affirmative action. Looking at now the promotion of racial equality by Congress, it can be argued that Congress is successful or has been successful in promoting racial equality through legislation such as the Voting Rights Act and the Civil Rights Act. Again, all of this we looked at in more detail in the previous video, so have a look at that one as well. Improved descriptive representation in Congress, promotion of African American turnout and rights, for example, Stacey Abrams, and combating voter suppression and promoting it in Georgia in the 2020 election, and also the impact of Black Lives Matter on congressional actions, which has significantly increased Congress, bringing issues of racial justice to the forefront of legislative and policy decisions. So whilst the George Floyd Justice and Policing Act was passed the House of Representatives, it did face challenges in the Senate, but the movement did have an impact in raising awareness about racial inequality, particularly in the criminal justice system, and has led to some policy changes at local and state levels. In terms of failures, again, all of these we've looked at in more detail in the previous video, but the Voting Rights Act can be seen as now undermined by the Supreme Court, because of Shelby County v. Holder, which renders key parts of it and effectively a lot of the Voting Rights Act inoperative. It can be argued there's still inadequate descriptive representation in Congress, particularly of non-white members of Congress. It can be argued there's been a lot of suppression of African American voter turnout, particularly in the 2020 election, and since Shelby County v. Holder, the introduction of a number of laws that limit the voting rights of polling places in predominantly black neighbourhoods, and therefore limit the right to vote of these traditionally marginalised communities. And finally, also there's been limited legislative success of the Black Lives Matter movement. Final key thing we're going to have a look at, which we haven't covered in previous videos, is immigration reform. We're first going to have a look at immigration and immigration reform under recent presidents. So under Obama, the Obama administration's approach to immigration balanced strict enforcement with measures to protect certain undocumented immigrants, particularly young people brought to the United States as children. One of Obama's key initiatives was the introduction of the Deferred Action for Childhood Arrivals, DACA, which is an executive order. It provided temporary relief for the deportation from deportation and work permit eligibility to young unauthorized immigrants, a group often referred to as dreamers. And by June 2016, it had accepted over 800,000 applications, primarily from Mexico, demonstrating its wide impact. Despite these efforts, the Obama administration faced challenges in passing the DREAM Act, which sought to effectively do the same, and effectively it sought to kind of provide a pathway to permanent residency for eligible immigrants who had entered the US as legal immigrants but as children. And effectively, Obama had to resort to DACA, doing it through an executive order, because he couldn't do so through Congress, because Congress refused to pass the DREAM Act. But it's also worth noting that Obama was known for stringent immigration enforcement, deporting more illegal immigrants than any previous administration, and this included the expansion of the Secure Communities program, which enhanced cooperation between local police and federal immigration authorities. Furthermore, the Obama administration issued significantly more fines and arrests for immigration law violations compared to previous administrations. Under Trump, the Trump administration's approach to immigration was characterized by its tough rhetoric and controversial policies. The administration's stance on immigration was a cornerstone of Trump's campaign, often using strong rhetoric that focused on reducing illegal immigration and emphasizing national security concerns. Trump's presidency included more restrictive humanitarian protections, a more closed-off US-Mexico border, and limited accessibility to legal immigration. The focus of his immigration policy was the US-Mexico border, but he faced challenges in building it due to Congress's refusal to provide the full funding he requested. This resulted in only partial completion, and although he declared a national emergency to redirect some funds for it after Congress refused to fund it themselves, this move led to legal challenges and controversy over the balance of power between the executive branch and Congress, and ultimately, the Trump administration was only able to build 455 miles of border barriers. It was a significant portion involving the replacement of existing structures rather than new construction. Another very controversial policy was the separation of children from their families, part of a broader zero-tolerance approach to illegal border crossings that led to widespread criticism. And the Trump administration also took a tough stance against sanctuary cities that limit their cooperation with federal immigration enforcement. On DACA, Trump initially vowed to end the program and sought to do so, but this was ultimately struck down by the Supreme Court. And later he showed some openness to protecting dreamers, emphasizing enhanced border security. A comprehensive solution for DACA recipients remained elusive. Despite these efforts, Trump did not achieve significant change in legal immigration numbers, except for a notable reduction in refugee admissions. Final thing we're going to have a look at then is Biden's presidency. So the Biden administration has reversed many of the policies introduced by the Trump administration. So upon taking office, Biden halted the construction of the Mexican border wall and ended Trump's travel ban on 14 predominantly Muslim countries. And these actions were part of a broader strategy to reform immigration policies, including reaffirming protections for DACA recipients and changing deportation practices to prioritize national security and violent crime concerns over petty offences. But the administration has faced surging numbers of illegal immigrants coming to the US through the US-Mexico border, and a political crisis as a result, with many Republicans attributing the surge to his administration's policies. So in December 2023, the US Border Patrol recorded nearly 250,000 migrant encounters, the highest monthly total on record, surpassing the previous peak of around 224,000 in May 2022. And this increase has been a trend since 2020, with numbers soaring past 200,000 on multiple occasions. And this led to widespread criticism from Republicans in particular, including Republican Party member and Texas Governor Greg Abbott, who has accused Biden of not effectively managing the situation and has taken independent action to prevent border crossings, including issuing an executive order to use for the first time the Texas National Guard and the Texas Department of Public Safety to apprehend illegal immigrants when this is normally a federal duty. In response to the criticisms, the Biden administration implemented several new measures in 2024 to manage immigration more effectively, and one significant step was to increase the use of expedited removal. And this means that individuals who enter the US without permission do not have a legal basis to stay and cannot be expelled under Title 42 will be subject to rapid removal to their country of origin, along with a 5-year ban on re-entry. In terms of summarising the successes of immigration reform then, on the one hand, immigration reform in the US, especially through DACA, has provided education and employment opportunities to young undocumented immigrants, fostering equality and access to resources and societal participation. The expansion of humanitarian parole programs under Biden for various nationalities creates a more equitable approach to asylum seekers and refugee policies. And the Biden administration's commitment to increasing refugee admissions, particularly from the Western Hemisphere, reflects a commitment to equitable treatment of migrants globally. So he set a refugee admissions target of 150,000 for both the financial year 2023 and 2024. On the other hand, there's been notable failures. The inability of the US government to pass substantial immigration legislation through Congress, such as the DREAM Act, highlights a failure to address the needs and rights of undocumented young people seeking a stable future in the country. The Biden administration struggled to effectively manage the significant influx of illegal immigrants at the border, underscores a systemic failure in creating a fair and effective immigration policy. And frequent shifts in immigration strategy, driven by changing political pressures and which parties in power, have resulted in inconsistent policies that fail to provide long-term solutions or equitable treatment. And finally, the inhumane treatment of asylum seekers in recent years, including prolonged detention and family separations, reflect a failure in upholding human rights and equality in the US immigration system. So yeah, that's everything in relation to the video. As you see, that was a very, very long video covering a lot of key debates that kind of touch on many of these kind of touch on previous videos and topics across the US Supreme Court and civil rights, which, as you'll see, is a very big part of the specification. So yeah, we've looked at kind of the Supreme Court first of all. Is it a political institution? And like building on this with living constitution versus originalism, and also does it have too much power and the role of the Supreme Court? And finally, the kind of measures on affirmative action and measures to promote equality and civil rights. We've had a look at a lot in previous videos, but it kind of replaces and shows how these can be used as arguments in essays. Whilst we also had a final look at immigration reform, which hadn't been introduced in previous videos. I'm sure I have a lot of questions in relation to that, so let me know if you've got any questions or comments in the comment section below. As I said at the start of the video, you should be, when you're watching this video, they may already be out, but very soon I'm releasing essay plans for the US on the Politics Explained website, which should really help you to kind of grapple with the amount of content, and they can be really useful for your revision. So yeah, let me know if you've got any comments or questions in the comment section below, and I'll see you in the next video.